Good day. My name is Shireen Noortir and I'm from the Financial Sector Conduct Authority, specifically the Conduct of Business Supervision Division. Today's session is on the actions leading to a license ending. And we're going to be looking at a number of different things that could lead to a license ending. So Section 7(1)(a) of the FAIS Act provides specifically that a license is valid from the date that the notice is gazetted to the date that the person is no longer issued with such a license. So if we look at Section 7(1), then it says that if you don't have a valid license, then you are not an FSP and you're not allowed to act as an FSP. So what are the reasons that your license could be revoked or that you're not licensed anymore? And there are three ways in which a license can end. The two issues that are highlighted in red is suspension and withdrawal, and those are punitive actions. And then we have a voluntary action or a non-punitive action, which is called a lapse. So we're going to look at suspensions and withdrawals first before we look at lapses. So suspension is catered for in terms of Section 9 of the FAIS Act, and that provides that the registrar may withdraw or suspend a license if there are, on the basis of available facts and information, enough grounds to identify that the licensee no longer meets the fit and proper requirements applicable to the licensee. And in those instances, certain actions will take place. So a suspension will not just happen out of the blue. A licensee will receive a notice of intention to suspend the license if there has been a material contravention of the FAIS Act or a financial sector law. So in that instance, the licensee is going to be issued with a formal letter, which is called a notice of intention to suspend. And the reasons for the intended suspension will be provided in that letter. The licensee then gets 30 days to explain why the regulatory action should not be taken. And if it is at all possible, then the licensee will also rectify the contravention in those 30 days. Now, if we receive the notification from the licensee and they respond and they give us the reasons why we should not continue with the regulatory action, that information is analyzed at our office. And depending on what we receive, we may then not proceed with the suspension. If, however, the licensee is unable to rectify the contravention in those 30 days, or they don't respond to us, or the response that we receive is not sufficient, then we, as the authority, may decide to proceed with the suspension. Now, in this instance, the licensee cannot act as an FSP, but the license has not been withdrawn yet. So in this situation, the contravention can be rectified. And then the licensee will have 3 months within which to comply with the terms for lifting the suspension. Now, it is really important that the licensee then do their level best to comply with the conditions that they have received, that they engage with the FCA, and that they rectify the situation. Now, if they are able to rectify the situation, they can rectify the contravention, then we will not proceed with the withdrawal of the license, because the intention to suspend and then the notice of suspension will actually act also at the same time as a notice of intention to withdraw the license. So if they then don't meet the requirements of suspension, then from the suspension we can go into the withdrawal process. Now, apart from the contraventions that we've just been discussing under suspension, there are also instances in which we can go straight to an intention to withdraw the license. And this is where the contravention is related to honesty and integrity related contraventions. The licensee will in that instance receive a notice of intention to withdraw the license. They will again be given time. In this instance, they will be given 14 days to explain why the license should not be withdrawn. And again, we will consider the information that we receive back from the FSP or the respondent, and they can then give us their reasons why we should not proceed. There are, however, some instances where we can proceed with the withdrawal of the license. So if the authority decides that there are enough grounds and reasons to withdraw the license, then we will proceed with the withdrawal of the license. If the license is suspended and the licensee fails to comply with the terms for lifting the suspension within the 3-month period that they've been granting, then we can also proceed with the withdrawal of the license. And the final one is that if the licensee fails to respond to the notice of intention to withdraw the license, then we will proceed with the withdrawal of the license. Because we do get it where licensees just don't respond at all, and in that instance we will proceed with the process. What is important to understand is that if a license has been suspended or withdrawn, or if a provisional suspension or was provisionally withdrawn, then the licensee may approach the Financial Services Tribunal and apply for reconsideration of the authority's decision in terms of Section 230 of the Financial Sector Regulations Act. We refer to that as the FSR Act. So there is a recourse even after suspension or withdrawal for the licensees as well. If we move on to lapses, then lapses occurs as a result of different reasons. And Section 11 of the FAIS Act provides for the different instances in which a lapse will take place. So a license will lapse where the licensee is a natural person and certain things happen to that natural person. So the first one is if I, as the licensee and a natural person licensee, become permanently incapable of carrying on any business due to physical or mental disease or serious injury, then the license will lapse because I'm the natural person and I'm unable to continue with the license. The second one relating to a natural person is if I am finally sequestrated, then my license also does not meet the financial soundness requirements anymore, and then my license will also lapse. And the third one is if I die, because the license is vested in me, with my passing, the license also ends. If we then look at the second big reason why a license can lapse, it is if a licensee that is the juristic entity is finally liquidated or dissolved, then the license also lapses. Or whether I'm a natural person or a juristic person and my license business becomes dormant, then my license also lapses. And then there is another case where the licensee voluntarily and finally surrenders the license to the registrar. And we typically find that people decide to go and pursue another avenue of business. They don't need an FSP license anymore, and then they will voluntarily and finally surrender the license to the registrar. Now, if the license lapses, there's a couple of things that must happen. The first one is that the licensee must inform us in writing about the lapse request, and they have to give us the reasons for such a request. Now, in that instance, we will investigate this and we will then finally lapse the license when we update our records, including the website. And we can also use alternative media platforms to announce the lapsing of the license. There are some other things that are very interesting to note in this lapse process. So we also have, in terms of Section 38A of the FAIS Act, provision for the voluntary sequestration, winding up and closure of a business. And I'm just going to take a little bit of time on this because not many people are aware of this and how it works. So a licensee may apply to the authority for the acceptance of a voluntary surrender of an estate, provided that such a surrender complies with the provision of the Insolvency Act and Section 38A of the FAIS Act. Now, the licensee must notify the authority if a resolution relating to the winding up of the company has been registered in terms of the Companies Act. And this notification must comply with the provisions of Sections 38B and C of the FAIS Act. And then finally, a licensee may also apply for voluntary closure provided that the authority has been notified in compliance with Section 38D. So Section 38 deals with the voluntary sequestration, winding up and closure of a business. And any of these actions will then automatically lead to the lapsing of a license in terms of Section 11 of the FAIS Act. So Section 38 provides that all of the actions that I've just described takes place, and we have to get notice by virtue of a copy of this being lodged by our office, and we then declare that this is acceptable or contrary to the Act. What is really important to understand is that when a license ends, there are obligations in terms of the General Code of Conduct that the license has against the clients and the product suppliers. And I've highlighted on this slide some of those sections, but I'm going to go on to a next slide and then unpack each of them in more detail. So in the instance where a license ends through suspensions, withdrawal, or lapses, the licensee must immediately inform all clients about the status of the license. So you have to engage all of your clients and you have to tell them that because of the following reasons, your license is no longer active. You also need to inform all the relevant product suppliers, and the relevant product suppliers here are those product suppliers with whom you have contracts, and especially those with whom you have unconcluded business. So you were in the process of a transaction on behalf of a client, whether it is a new policy or investment that you were helping the client with, changes to existing policy or investments, or claims against policies, or the ending, the withdrawal from an investment product. So all of those are unconcluded business. And you then have to make sure that you engage the client and the product supplier to make sure that the client is not placed in a prejudicial situation. So you have to inform the product suppliers, and then where there are pending business, this unconcluded business, you have to take reasonable steps to finalize this. Where you are unable to finalize this, you have to make sure that the client is actually transferred to an authorized provider who can assist them. And this is not only for unconcluded business. The clients must also know who can they contact in the future, because they have existing financial products with a provider. You were acting as the intermediary, and they now need to know who they can contact to assist them in that situation. But this doesn't happen in isolation. So it's not just a case of transferring clients to another provider. Section 3.3 of the General Code says very specifically that a provider may not disclose any confidential information acquired or obtained from a client, or, subject to Section 4.1, a product supplier in regard to such client or supplier, unless the written consent of the client or product supplier, as the case may be, has been obtained beforehand, or disclosure of the information is required in the public interest or under any other law. So I'm just going to go back to the previous slide. So what this says is you have to notify the clients, you have to notify the product suppliers, and you must make sure that the clients are assisted to finalize any pending business. And the client must also know who to contact in the future, because they have existing policies or investments. And the mere fact that the FSP as the intermediary is not going to exist anymore because the license is ending doesn't mean that the client's need for service is ending. So who must they contact in the future? So a lot of businesses think that they can just transfer the clients now to someone else, and the other provider will continue to provide the service. But now we sit with Section 3.3 that says, hold on a moment, you're not allowed to provide information about the client or another product supplier, as the case may be, unless you have their written consent. This means that you have to make sure that you obtain the written consent of the client before you provide their information to another FSP. So provider in this instance becomes FSP. So one FSP is not allowed to transfer my information as client to another FSP, even if you do it with the best of intentions, if I haven't given you my consent. So one of the things that we would ask when we get a lapse request from an FSP is, have you notified your clients and have you obtained their authorization to transfer their information to another FSP? And have you notified the product supplier, because the product supplier must also make sure that there is no unconcluded business. And when we receive your confirmation that this has been done, then we will proceed to lapse the license. And as I've indicated already, the lapse is finalized when we publish this. And normally it's by notice on the website. Until that process has been concluded, the license is still active. So we will not continue to process the lapse until we're satisfied that the clients have been placed in a position where their business is concluded and it's concluded in an orderly manner. So these are important requirements, and we really would like to bring your attention to that. Something else that we receive questions about is, does this apply only to local or South African-based FSPs? These requirements apply to any FSP regardless of jurisdiction, as long as you are a licensed FSP in terms of the FAIS Act. So regardless of whether you are based in South Africa or based in another jurisdiction, if you have an FSP license, all of these requirements apply to you. So just to summarize, licenses can end as a result of a suspension that is not lifted, and the suspension turns into a withdrawal. A license ends as a result of a withdrawal, which is the action where the FSCA takes away the license from the FSP, or a license can end when a lapse request has been received from the FSP, and there are various reasons for lapses. We also sometimes get questions where people say, I lapsed the license in 2000X. It's now 2021, and I actually would like to have a license again. Am I allowed to apply for a license again? Yes, you are allowed to apply for a license again. The application does not guarantee that the license will be granted, but there is nothing that stops you from applying for such a license. So I do hope that this has been of use. We have another webinar that deals in great detail with regulatory action and explains the reasons for suspensions and the reasons for withdrawals in more detail. So if this is a topic that is of interest to you, can I also point you in the direction of the webinar on regulatory action? You'll find that that provides quite a lot of very useful information. And then lastly, we have accredited this webinar with the Financial Planning Institute for CPD purposes. And if you would like to obtain CPD recognition for having attended this webinar, please complete the assessment that is linked to this webinar. And on your successful completion of that assessment, you will then be able to download and save the certificate of completion for your CPD records. If you battle with the assessment, then please watch this webinar again, because all the questions in the assessment is based on the slides and the discussion of this webinar. And the same is true for any of our other webinars as well. Thank you very much for your interest, and we hope that you will attend many of our other webinars as well. Take care and be safe.